Okay, so we're now going to look at the last 3 deposition transcripts that are attached to Wayfarer's unsealed documents. We're going to start with Warren Zavala, the WME agent for Lively. Okay. So I'm not quite sure what the discussion about, and he says, yeah, my takeaway here, it included hugging, no physical touching. Like, she just didn't want to be. There was an established feeling, I think, on her part in terms of the interaction with them. And I think she wanted to be very clear as to the demarcation line of what was okay and not okay with this return to work. Okay, so they're talking about the return to work. I think it's very specific because she didn't want there to be any confusion going forward. Garofalo objects. Mr. Zavala, do you have people that report to you? And he says, no. I mean, I have an assistant. I don't know if she exactly reports to me. And would you tell your assistant that she's hot or sexy? Oh, for God's sake. It is not the same context. And actually, even Lyman made this distinction that it is not the same as a movie set where the director is specifically opining on the look of the wardrobe and basically referring to it exactly as Lively herself described. It's not the same. Would you tell your assistant that she's hot or sexy? Objection. No, I would not. Why wouldn't you do that? Garofalo objects. Bruno says you can answer. And he says, because I'm in a position of relative power to my assistant and it would be inappropriate. I mean, firstly, you'd think he'd want to point out the fact that he's a married man. But secondly, if anyone thinks that Justin Baldoni had power over Blake Lively for even a second, but also that, in the same time, Lively was quite happy to have Baldoni over to her apartment, right? This guy who's got this power over her, and let her husband scream at him for 6 hours. You're fucking insane, right? There was no power imbalance. Certainly not one that, benefited Justin Baldoni. That's just ridiculous. Okay. And bring it back to this context. Would that same principle apply? And he says, yes, in my mind. Why is that? Because he was in a position of power. Yes. Yeah, sure. Because, it's not like he had a Warren Zavala to call in favors from Tom Rothman, the chairman of Sony, or an Ari Emanuel to go full Ari, is it? Yeah, but he's the one that's in a position of power. Oh, based on what? For Wayfarer Studios, the producer, the director, and the actor in the film. Okay, now if you turn the page to the 6th condition, it says no one will attempt to enter, interrupt, pressure, or request entrance to artist trailer while she's in a state of undress for any reason. Do you see that? Yep. Do you know what that's in reference to? It's a good reminder. I did leave this one out. Yeah, she felt like they were, and we don't know because it stops there. Oh, it's just ridiculous, that is. Okay, let's go to Jeffrey Kinrich. Okay, and we continue. Okay, so the question is it your understanding? Let's start with Betty B. Oh, by the way, Jeffrey Kinrich is obviously one of the, I think he's one of the damages experts. Is it your understanding that, let's start with Betty B, Blake Lively would not be entitled under the corporate documents to the value of lost cash flows at any point? As an objection. Kinrich then says, that sounds like a legal question. It's not within my expertise. So this is Amir Kalkrad, who's one of Wayfarer's attorneys. Okay, well, do you have an understanding that if the company distributed all of its profits today, would Miss Lively be entitled to the value of lost cash flows? Do you have an opinion on that? Objection. Are you distinguishing in that question between cash flows and profits, or are you not intending to? I'm not intending to. If the company made distribution, she would get her share. What do you mean by her share? It would flow through various entities and she would ultimately benefit from her shareholdings. So is it your understanding that if she, just make sure this continues, that if she has a certain interest in the company, that's the amount of lost profits or cash flows, I'm using that interchangeably at this point, that she would receive if the company distributed those profits? Objection. Unless there's a subtlety that I'm missing, the answer is yes. Are you aware of whether the corporate documents of Betty B describe how distributions are made to shareholders? I'm not aware. I would have to go look to answer that question. Are you aware whether Betty B has any direct ownership interest of Betty B Holdings? Objection. You mean as opposed to through Lol Hatter, for example? Yes. My understanding is all of her businesses are held through her, I will call it business holding company. That's my phrase. Not meant to imply anything other than I don't know what else to call it, which is Lol Hatter. If you look at paragraph 21 of your report, you say, the profits under each scenario are calculated using a discounted cash flow, DCF approach. Do you see that? I'm sorry, what page? Paragraph 21. Yes, I see that. Did you consider any other approach to calculating lost profits? I guess conceptually I did, because I'm always thinking at the beginning of any case I work on, what are the approaches that make any economic or logical sense? I didn't spend any great amount of time on any other approaches because no other approach seemed to be relevant in this case. So, there wasn't more than, 2 seconds worth of consideration, but I at least tick through them and then it goes to a different page. Okay, so I was reading. I calculate the but-for value of Blake Brown to be $108.6 million as of March 31st, 2026. You can see that? I do. And you reference Exhibit 1 of your report, so I'm going to turn to Exhibit 1. I think the exhibits are before the appendices, if that clears up my current problem. Thank you. All right, I'm there. All right, and I'm just looking, at note number 1, which says, Ms. Lively owns 100% of Lol Hatter, which owns 40% Family Hive as of March 4th, 2022. This analysis assumes that Family Hive owns 100% of Blake Brown. Do you see that? I do. Do you know whether Ms. Lively still owns 100% of Lol Hatter? It goes into the next page. As an objection, he says, that's my assumption, and that is what I believe to be true. I don't have personal knowledge. Do you know if that percentage has ever changed? Objection. Same answer. Do you know if Lol Hatter still owns 40% of Family Hive? That is my understanding and assumption. I have no personal knowledge other than that is what I'm informed. And what is your understanding based on? That's what I've been informed. Were you informed by Family Hive? Objection. I was informed by my staff who has inquired and received that information. Do you know if that percentage has ever changed? I don't know if it was something and it stops. That question, the person who's asking the questions has the answer. They're taking you somewhere on a little adventure when they start questioning you like that. Like they get you to kind of commit to an answer and they say, is this still your understanding as of today? Are you aware that anything's changed? Are you sure? Would you like an opportunity to revise your answer? That kind of question. When you get that type of questioning, the person asking the questions already has the answers and is guiding you on a little adventure together. And it's great fun to do that. Okay, and then we have Laura Tradesco, who is she was the deponent for Family Hive. Okay. So we're going in halfway through a question. Permitted under the company services agreement. Is that right? Correct. Okay, if I go back to section 4.1.1, the royalties section. Okay. Now this section provides that the company shall pay to the lender. So the company pays the royalty directly to Lol Hatter, correct? Correct. It does not pay Blake Lively directly, correct? We pay Lol Hatter, correct? Directly. Okay, but there hasn't been a time where you've wired a transfer to Blake Lively or written a check to Blake Lively in her personal capacity. Every payment for royalties has gone to Lol Hatter. Is that right? That is correct. So again, what capacity or standing does Lively have to sue in her personal capacity? Because under the ordinary course of business, she would not be paid directly. She has never been paid directly. Okay, so under the agreement, 5% of the wholesale gross sales equals the wholesale gross royalties. And do you know that the wholesale gross? Do you know what the wholesale gross sales were? In 2024. Of that, and again, I usually work a little bit more on net sales. If you were to gross, we're going to a different page, yeah. Halfway through a question, you look at section 4.1.2, that's titled additional royalties. Do you see that? I do. Okay, now those additional royalties only become a factor after 5 years after launch. Isn't that correct? That is correct. Okay, so would it be correct that Lol Hatter has not been paid any additional royalties pursuant to this section since launch? That's correct. Okay. So additional royalties only come in 5 years after launch, and if this is the company has not even been launched for 5 years, so Lol Hatter has never been paid these additional royalties. But Lively's still trying to claim all of this shit. Oh. Okay, so would it be correct that Lol Hatter has not been paid any additional royalties pursuant to this section since launch? That's correct. Does this promotional services license agreement accurately describe Lol Hatter's entitlement to royalties from Family Hive? Yes. There's an objection. And the witness says again, yes. Calcrad, to your understanding, does Blake Lively have any direct entitlement to royalties that doesn't go through Lol Hatter? Not to my understanding. My understanding is everything goes through Lol Hatter. And then that's it. That's the end of that. Okay. I'll have a look at the other exhibits and see if there's anything interesting there. Given that the case is now done for, I'm not sure if there is going to be much more to go through. One thing I will say as well is this settlement, now unless because obviously the terms of the settlement are confidential, we do not know what they are. So unless Wayfarer waiving their right to appeal the dismissal of their lawsuit against Lively was a condition of settlement, then they do still have that right of appeal. I don't know, I may have already said this, right, but I can't remember. I do want to make it very clear. So the two things are, unless they are conditions of the settlement, if they're not conditions of the settlement, then they are not affected. And those two things are the motion for section 47.1 fees and Wayfarer's right to appeal their lawsuit because it is a separate lawsuit. Okay, so Lively's is done, and Lively can't appeal it. The Wayfarer v. Lively case, though, with Wayfarer's complaint, that option for an appeal is still there. It is a separate lawsuit. And also the motion for the fees attaches to that lawsuit because Lively is requesting the fees because Wayfarer brought that lawsuit. So the fact that Lively's is now done does not automatically negate these two things, because although they were consolidated cases, they are still separate lawsuits. Wayfarer brought, its own lawsuit with its own causes of action, and sued specific parties, who some of whom weren't even on Lively's lawsuit. So, although the defendants were the same, although the plaintiffs in Wayfarer's lawsuit were the same as the defendants that were in Lively's lawsuit, the defendants that were in Wayfarer's lawsuit, which included Ryan Reynolds, Leslie Sloan, New York Times, were not the same. They have never been in Lively's lawsuit. So there are differences. It gets confusing, and people often think because they were consolidated that what happens in one automatically will take the same effect in the other, and that is not the case. So we know that Wayfarer hinted in the New York Times case for fees, the anti-SLAPP case, that, they still had the right of appeal. They still do have the right of appeal.